The Honorable Justices of the Supreme Court, hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention to the court.
Good morning. I'd like to welcome you to today's docket, which falls on a special holiday, Constitution Day. Constitution Day was established by Congress in 2004. The day recognizes the anniversary of the signing of the United States Constitution by delegates of the Constitutional Convention on September 17th, 1787. The purpose of celebrating this holiday is multifaceted. One purpose is to stimulate a deeper understanding of the Constitution and to encourage study of the document. To help with that effort, you will find a new page on our kansascourts.org website dedicated to the Constitution Day. You can take some time to explore that page and you'll find many links that will take you to various places, and you can even quiz yourself on your historical and substantive knowledge and otherwise reflect on the 4,400 words of that important document. The holiday also gives us an opportunity to reflect on the value of the American experiment, the success and the failures of a nation of free people whose rights and liberties are protected by our written Constitution. The importance of that document to these court proceedings is underscored by the first 17 words of the Constitution's preamble. We, the people of the United States, in order to form a more perfect union, establish justice. We will now set about the work that underscores that goal. And to do so, I would ask Mr. Doug Shima, the clerk of the Kansas Appellate Courts, to please call the 9 a.m. docket.
Thank you, Your Honor. May it please the court. The 9 a.m. docket for Friday, September 17th, 2021 consists of one case, Appeal number 122301, State of Kansas versus Denis Antonio Alfaro-Valleda, Wyandotte County, briefs both sides. The appellant has reserved 3 minutes rebuttal time. Your Honor, we are ready to proceed.
Thank you, Mr. Shima. Counsel, would you please state your appearances?
Your Honor, my name is Randall Hodgkinson. I'm appearing today on behalf of Denis Alfaro-Valleda, and I'm ready for argument.
Madam Chief Justice, and may it please the court, the State of Kansas appears by Assistant District Attorney of Wyandotte County, Daniel Obermeyer, present and ready for argument.
Thank you, counsel. Mr. Hodgkinson, you may begin your argument.
Your Honor, just as a reminder, this case is a first-degree murder case out of Wyandotte County. The facts were that the decedent in this case was shot outside of his car, and the state prosecuted my client for that murder. And he was convicted and is serving a life sentence in prison for that murder. Your Honor, there were several issues raised in this case. I think that as I reviewed it, I thought the briefs did a pretty good job of sort of setting out the issues and the arguments and the disagreements. So I just was going to highlight a couple of things and see what the court had questions about. The first issue in this case had to do with the admission of an autopsy photograph in this murder case. Now, it's certainly not unusual to have autopsy photographs in murder cases. Pretty standard, really. What was a little bit different about this case was there wasn't a coroner testifying, which is a little unusual in a murder case. I suppose not unheard of. And as my colleague notes, there's no particular requirement that a coroner testify in a murder case if other circumstances show the cause of death. And in this case, there were circumstances without the coroner's testimony showing that the victim in this case was shot, and as a result of that shooting died. So the question in this case, though, is whether or not this particular exhibit, which was a photograph of the decedent in this case, an autopsy photograph with essentially the back part of his skull removed, showing a bullet, right? And this is admitted after an officer who was present during the autopsy testified that he saw the coroner remove a bullet from the decedent's head. And so the question in this case is whether or not this exhibit is sufficiently probative to outweigh its pretty significant prejudicial value, prejudicial effect, I guess, in this case. And we have a legion of cases where the court has said autopsy photographs are often helpful when coroners are testifying, but that's not relevant in this case. And this court also has indicated that autopsy photographs or other kinds of gruesome photographs may be relevant and very probative if it shows the nature or extent of wounds caused on the decedent in a murder case. And in fact, in the appendix, I mean, there were other photographs, autopsy photographs admitted in this case, showing, for example, the bullet wound in this case. But the photograph that's the subject of this issue wasn't an injury caused by the shooter in this case. It was disfigurement caused by the coroner in the course of that normal job, but it doesn't depict the wound or injury in this case. It's something completely different. And because the coroner didn't testify in this case, and because it doesn't depict the actual wound, it depicts something that happened long after the shooting in this case. It's certainly our position that none of those cases talking about the probative value of autopsy photographs is very persuasive.
Mr. Hutchinson, was the basis of the objection was your typical, especially gruesome, doesn't add kind of cumulative objection. It didn't really tie to the fact that there wasn't the coroner that didn't testify. You're tying it to that, but I don't think that was the objection specifically before the court, was it?
Well, I certainly think in the context when they were discussing this, the discussion was that there was no coroner here. And in any case, there certainly was an objection based on gruesome photographs. And so to the extent that that objection is there, I mean, that's shorthand. There's no such thing as a gruesome photograph evidentiary objection. We all know what that is. It's a more prejudicial than probative objection. And so I think the analysis that I'm putting forward is correct, whether they ever use those words or not. And by the way, I mean, my colleague notes that this evidence was probative because it corroborated the detective's testimony that the coroner found a bullet in the decedent's head. And that's true. I mean, there's some probative value, because if there's no probative value, then we wouldn't be taking this step. It wouldn't be relevant, right? So every time we have a gruesome photograph issue or a prejudicial versus probative issue, there's some probative value. The question is whether there's sufficient probative value in light of the entire context of the case to overcome what may be some prejudicial effect, like an autopsy photograph showing a very disfigured victim. So our argument in this case is there probative value? Of course, otherwise we'd be doing a relevance issue. But the probative value in light of the fact that there's no coroner testifying, in light of there's already unobjected to evidence of the bullet wound in this case, and in light of the uncontested evidence of the detective saying that he saw the coroner take the bullet out of the decedent's head, that the probative value in this case is extremely low, but that the prejudicial effect of this disfigurement by the coroner can still be very high. And therefore, the district court abused its discretion by admitting this evidence.
Counsel, can you articulate with a little bit a higher degree of clarity what the prejudicial effect of this is? Because it's an autopsy photo, and doesn't every ordinary juror understand that those are going to be gruesome? It's an autopsy photo. It's
an autopsy photo, Your Honor, but I think it's an interesting question in that you and I and the court and my colleague, live in this world where we look at things like this often, and unfortunately, maybe. And so we're sort of like, it's an autopsy photo, we know that. But the effect on an average juror, we know, and this court has said before, that even autopsy photos can and often do have this prejudicial effect, that it shows this disfigurement and is likely to cause an emotional reaction. Your Honor, I was talking to my wife getting ready for this case. She's just talking about what are the issues in this case. And I said, oh, well, it's this issue about this gruesome photograph, and it's this autopsy photograph with the back part of the decedent's head removed. You want to see it? She's like, no, I don't want to see that. Why? because I think most lay persons that don't live in our world where we look at autopsy photographs on a fairly regular basis do find them emotionally charged and laden. That's why you've said before, autopsy photographs can have this effect, often do have this effect. And in this case, there's no reason to think it wouldn't have had that effect in this situation.
Counsel, there was a lot of blood that you could see around the wound that you wouldn't have been able to see if the skin hadn't been pulled back. Is there any argument that that has relevance separately to show that there was a lot of bleeding at that point?
I haven't seen any articulation of that as a relevance. I mean, as far as there was, again, a lot of testimony, for example, at the scene that there was a lot of blood and that there were different injuries. And again, all of that, none of that was objected to because we recognize, I think, that it's relevant, that those facts about the injury are going to be relevant. And the photograph, for example, of the bullet wound is relevant. But I'm not sure what that would add to the argument. And whatever bleeding there is showing sort of in that autopsy photograph, I'm not sure that it's as a result of the bullet wound. And then certainly there was no testimony to that regard, probably because the coroner didn't testify in this case. I mean, could there be a world in your circumstances where the coroner is testifying about, look at all the injury inside of the head that, caused by a bullet? In fact, that's what a coroner might typically testify to, but that's not this case. And in fact, the state acknowledged their detective wasn't there to testify or give any sort of expert testimony about the effect of the bullet and its possible cause of death. It was only to testify that there was a bullet found by the coroner. The other point that I might make with my remaining time had to do with the instruction regarding hearsay or non-hearsay, depending on your point of view in this case. And I just wanted to touch on this, that, here at the law school, we teach, evidence, and you all have had it, we've all had evidence. And I think we spent about a half a semester trying to get people to understand this concept of hearsay and that, what is it? It's an out-of-court statement. Well, it's not just an out-of-court statement. It's an out-of-court statement offered to prove the truth of the matter asserted. And then we have to understand that, well, we can have some out-of-court statements that aren't, introduced for that purpose. And that's fine. And so we all learn that. The purpose or the idea behind our instruction issue in this case is maybe we need to get let jurors in on that secret. That there can be some cases where statements are admitted properly under our hearsay rule because it's not hearsay because it's not being offered for the truth of the matter asserted. But unless our jurors are sort of clued in on that legal reality, how can we expect them to know that? And that's the basis of that argument, is just simply to say that it is appropriate in a case where a jury, in fact, is told you should consider all evidence for all purposes. That's the general instructions that are given to juries. That how would they know that they couldn't consider it for substantive purposes? So that's the basis of that issue.
Mr. Hodgkinson, I'd like to go ahead, Justice Wall.
Well, thank you. I was just going to ask if you could articulate your clear error argument, given the nature of the hearsay or the non-hearsay statements at issue in this case, because they seem relatively minor on their surface.
Sure. And so as is, I suppose, often the case, my colleague, thinks this is the greatest prosecution in forever. And I, as a defendant, think, this is the weakest prosecution for whatever but I think when the court looks at the entire context for a harmless error or a clear error analysis in this case, you have to look at what was the nature of the state's prosecution here. And with regard to identity, this was a hotly contested case. And so the content of the statements in this case went directly to that question, because they were sort of, what was the decedent's motive or intent at the time of the killing in this case, and what was my client's motive intent after the killing in this case. And those go to that question of identity, and is why we think that there could be a reasonable probability that the outcome would be different.
One of the statements referenced moving the defendant's vehicle, but the other statement was relevant to the victim, I believe.
Right. The motives or intent or the actions of the victim. What was the intent of the victim? And the point being, I mean, my client's theory is that there was something else going on here, that there was some other motivation for somebody to be involved in this killing. And so the decedent's statements in this case were, that they were just innocently going about this business of taking somebody home. And so the truth of that matter is important when you determine if the jury believed that, then that undercuts my client's theory that something else was going on here. Your Honor, I see my time is up.
I wanted to probe the argument of the state about the impact of the language in KSA 64406 that says that the court, upon request, shall give an instruction about the proper scope of the evidence. I take that as an argument that 406 is more specific than our clear error jury instruction statute. Could you, and I know we have cases that have said we've applied clear error even if there was no request. My inquiry is, were those cases rightly decided? And is the state correct that 406 is more specific and a request is necessary before we get to the clear error in this case?
No, Your Honor. It's certainly the case, I believe, and I hope this court would hold, that it's a district court's responsibility in every single case to always accurately inform the jury of the law. In fact, I think that's the district court's primary job at a jury trial, maybe, is to accurately instruct the jury on the law. Now, that statute certainly says, and is an option, a avenue for the way that a party can try to make the district court do that, but it doesn't limit it. It doesn't say only upon request should the district court accurately advise the jury about the law in this case. So I don't, our position, and I think the reading of the statute doesn't place that kind of limitation on it, that the general law that this court has promulgated, that district courts are responsible to accurately provide the law to the jury, is true in every case.
Is this one of those areas where the legislature recognized the tension that is often argued about when the court does do that and instructs in some areas, it might be actually interfering with the theory of defense and a strategic decision that the defense has made not to have an instruction like that for the jury?
Your Honor, I'm not aware of, and I'd be surprised if the law of this state is that the parties get to sort of game the system for their strategic advantage, including whether or not the district court accurately informs the jury of the law. And so, for example, there's a lot of instructions that are given that don't particularly help my clients in a lot of cases that I would say I don't want. I might object to them. But if the answer is, but this is a legally and factually appropriate instruction, it doesn't matter whether it impairs my defense. Now, I might still object to it, but that's not the answer to the question. The question, I think, in all cases should be, is this a legally and factually appropriate instruction?
The exception, the reason there might be an exception here is going back to really the fact that the legislature didn't have to create a clear error standard at all. It could be that the typical preservation rules would apply here, would apply to jury instructions, and that without jury instructions, without an objection, without preservation, there might not be an ability to appeal at all. So the legislature's already given something. And so why in one instance could they not pull back from that and say, no, this is an area there has to be preservation? I
think unless there was a really clear indication from the legislature that there's a specific species of instruction that they don't care whether it's accurate, that you can't appeal that. I think the court should tread pretty carefully there. And the procedure in the statute cited by the state, that's a procedure whereby the parties can do this, but it doesn't restrict it to that. There's nothing in the language that restricts it to that.
Thank you. Are there other questions?
Thank you, Your Honor.
Mr. Obermeyer?
Madam Chief Justice, and may it please the court, I'm going to begin my argument by just fleshing out some of the facts of this case a little further, as I think it's relevant in any harmless analysis which this court may imply or may apply. So the basic facts are that this party was happening for New Year's, as parties often do. One of the people there was the victim in this case, Mike Hurtado. He had been dating for the past few months, Frances. Frances was the ex of the defendant, and they had a child in common, as a matter of fact. And in the state's theory, when the party was winding down, Mike says to his sister that he's going to drop Frances off at her house and then he's going to come back to the party. And when he does get back to the general area, the parking lot where his sister's residence is, he is killed outside of his car. Police investigate this matter and they find that Frances had been dating the defendant, so they want to check him out as a suspect. The defendant, meanwhile, goes to a friend and they decide to go on a road trip to Texas. This is they take the defendant's small child with them. They don't really have any food or clothes or anything to sustain them on a road trip. They're detained, the defendant's arrested, and he gives a statement to police, and well, two statements actually. The second statement is the more important of the two. In that statement, he basically says that Frances egged him on to kill Mike to prove his love for her, and that he did. He makes references to her setting a trap and to him walking into it. And so that's the basic outline of the evidence. That was the most damning evidence, at least the state presented. The state also presented evidence that the defendant in his vehicle was following the victim shortly before the victim was killed. Taking the first issue that the defense raised, the autopsy photograph, that's the defendant or counsel is correct that the state did not present evidence from the coroner. The state explained that the coroner that performed the autopsy in this case was in Australia. They had made arrangements to get another coroner there, but essentially the prosecutor's statement was it really wouldn't add anything that the CSI officer that attended the autopsy could add. And it's interesting in this case, the objection that was made, I mean, yes, you can construe it as a general gruesomeness objection if you would like, but it begins on page 259, 260 of volume 13, and the defendant, and he's objecting to another photo where the testifying officer is saying that there's a gunshot wound, and the essence of the defense counsel's objection there is, I don't think he can say this is a gunshot wound. And the prosecution responds that, well, he's going to show bullets removed from these wounds, so it's relevant for that purpose, and the court allows in the autopsy photos for that purpose. So it is a little bit, there is a little bit more of a nuance there. Reviewing case law, as counsel also noted, I couldn't find any requirement from this court that the state had to present a coroner in order to present an autopsy photo. I think that that's fairly a matter of common sense for a jury, that autopsy photos are going to be more gruesome, if you will, than ordinary photos, for lack of a better word. Regarding the hearsay or non-hearsay statement in this case, again, what we have here is evidence which, as 6407F says, is admissible for any purpose because it's non-hearsay. it's a little bit of a trick because the reason why it's not hearsay is because it's not offer for the truth of the matter asserted. My argument in raising 406 in this, the no instruction, is because that is a provision which specifically addresses when and how a district court should limit evidence. Obviously, some evidence is relevant to prove one element of a crime, but not relevant to prove another element of a crime. Where the crime takes place doesn't really have a bearing other than the jurisdiction. And if taken to its logical conclusion, I think that the defendant saying that the district court needs to spell out precisely what this evidence is admissible for this specific purpose, that will have a I think that's the reason why the legislature included 406. If you're offering it for a purpose, then and it's not admissible for any other purpose, then you shall issue a limiting instruction. And that makes sense that a council may want to limit, for example, in the 6455 realm. That makes sense to have a limiting instruction because these are by their nature prejudicial. This is prejudicial evidence that you may want to instruct a jury is only admissible to prove intent, plan, motive, what have you. In this case, the statements are clearly non-hearsay, so under the general provision of 407F, they should be admissible for any purpose other than the truth of the matter asserted, which really isn't in dispute. I believe the record will correct me if I'm wrong on this, but Francis testified that Mike did indeed drop her off, and certainly it's obvious that Mike was returning to the party. So in terms of harmlessness analysis, I don't think that really has anything requiring reversal. If the district court should have given a limiting instruction, it was not. Unless there's any questions on that issue, I'd like to move on to the prosecutorial error issue. In terms of the prosecutorial error issue, this is another, I'd ask the court to reconsider its opinion in State versus King, where it held that the prosecutor cannot use the phrase "we know" to draw reasonable inferences from the evidence. The prosecutor, in my reading of closing argument, and as I argue in the brief, did in fact use "we know" numerous times. Some of those times, counsel does not contest as being proper within the meaning of King. My argument is that on one of those occasions, the prosecutor, if the court does indeed adhere to its precedent in King, he did commit one King violation. But and my argument for harmlessness is there. But I would ask the court to reconsider whether or not a prosecutor can use "we know" in drawing reasonable inferences from the evidence. I think that Kansas is in the minority of jurisdictions that hold that as a per se rule. It seems that the majority of jurisdictions that have addressed this issue, and this is within my research, obviously, it's obviously searching for prosecutorial error, prosecutorial misconduct, and then the phrase "we know." I've cited the cases that I could find that have addressed this issue, and it seems like the majority jurisdictions are fine with a prosecutor using "we know," so long as they're clearly directing it towards the evidence and not suggesting to the jury that the state has some sort of secret knowledge or that there's other evidence which is not presented showing that the defendant is indeed guilty. And part of the reasoning in King, King based its decision on that and based on the decision in State v. Corbett. And my argument is that Corbett, it really didn't have much of an analysis one way or the other as to whether the phrase "we know" was error. Corbett, as I read it, basically said this was not error for the prosecutor to use "we know" because he was talking about uncontroverted evidence. So that seems to me a little bit of a far cry from a prosecutor they can't use "we know" to draw reasonable inferences from the evidence, especially when he's talking about the evidence.
Isn't the problem, counsel, really that the prosecutor is putting himself into the jury box as implicitly another fact finder. We're all here together and we know.
Well, certainly that is a construction that you can put on a prosecutor's words, but I don't think that we should necessarily put the most damaging meaning we can put on a prosecutor's words. So the prosecutor in this case begins using "we know" and clearly asking rhetorical questions. How do we know it was the defendant? And then he directs the jury to the evidence showing why the defendant is guilty. I think that my reading of King and Corbett, it's not just the prosecutor putting himself in the place of a jury. He's expressing his personal opinion. I think characterizing King more or less correctly on that. And when you're backing up your argument or your "we know" with facts, or at least evidence, whether they're uncontroverted or not, that sort of removes you from the "this is my opinion." Now, certainly, so long as they do that, I don't think it should be within the realm of prosecutorial error.
What if you substitute "we know" for "I know"? Would you make the same argument?
I would not make the same argument under these.
So very quick follow-up, doesn't "we know" encompass "I know"?
Well, I
is part of "we," grammatically speaking, right?
Yes, it's the first, "we" being the first person plural, and "I" being the first person singular. But when you're, it's more of a rhetorical device, and I think that's what a lot of jurisdictions have held. If you're using it to discuss the evidence and draw reasonable inferences. Obviously, in the context of a jury trial, the prosecutor has been with the jury every step of the way and hearing the evidence, and everything that he's saying is things that quite literally they all know because they've all heard it. So in that sense, it's not very, it doesn't seem to express a personal opinion in the same way that "I know" does. And of course, this court has said that prosecutors should use "I submit" if we already use the first person singular at all. And I certainly have no problem with that. But in context of trial, I mean, essentially, when you're adopting a conversational attitude, I don't think it's out of the realm of the reasonable to say, "we know this because this, this, and this." And unless there are any other questions on that issue, I'll move on to the next.
Are you arguing then that it would be incumbent upon the defense to ask the court to give a limiting instruction to the jury that this is only being used as a rhetorical device?
No, I would not. I think that's fairly well covered in the instruction that the arguments of counsel are not evidence. And you should use them, but and you should use them in coming to your deliberation, but they're not evidence. The prosecutor's not testifying, and certainly defense counsel is free to use that in their closing arguments, and prosecutors are free to use that in their closing arguments. I want to touch briefly on the fourth issue, the defendant arguing that the "not guilty" should be placed first in the verdict form. The essence of that argument, as I read the defendant's brief, and I'm running out of time, so I don't mean to oversimplify Mr. Hodgkinson's argument, is that scientific studies show that first is best, therefore "not guilty" being consistent with should be placed first, being consistent with the presumption of innocence in this case. I think that that's a very specious link, if you will. I don't think that has just because you can phrase a jury instruction in a way which will favor the defendant, that there's no requirement that the district court has to do that, or the state has to do that. In closing, I would ask this court to find that there were no trial errors committed, that limiting instruction was not necessary for the non-hearsay statement. And I'd ask the court to reconsider its precedent in King, especially in light of this prosecutor's oral arguments or closing arguments. I would ask the court to affirm the defendant's convictions and sentence.
Thank you, Mr. Obermeyer. Mr. Hutchinson, you reserve 3 minutes.
Thank you, Your Honor. I guess since I have the time, and I'll maybe engage in a little commentary on the last issue, which has to do with long ago, 30 years ago, this court said, in response to this argument that maybe not guilty should be first on the verdict form. This court said, look, there's no evidence that this makes any difference in the decision-making process of the jury. So that's not a good argument. So we're putting forward this. There's some empirical evidence in this article that the way options are presented may have an influence on choice. Now, I admit it's not the perfect fit. It's not a study of jurors, but it does, I think, provide some evidence that in some cases, the order in which options are given can have an effect on a decision. And that may be relevant in marketing areas or on election ballots. And there's no reason why it wouldn't apply in jury verdict forms. Maybe the court doesn't find it very persuasive. I don't know. Here's the thing. It seems to me, and maybe you can tell me where my logic is wrong, that either I'm right or I'm wrong. And we can do a Westlaw search and know statistically I'm more often wrong. So let's assume, though, for this second, the exception that the exceptional case that I'm right, and that there may be some possible impact of the jury verdict form on the decision-making process of the jury. If that's true, then it certainly is the case that it would be the appropriate practice to list not guilty first. Otherwise, it will have the effect of, in some way, diluting the presumption of innocence. Whether it would ever be enough to be reversible error, I don't know. But it would be legally correct to say we don't want to do anything to dilute the presumption of innocence. Now, the other possibility, and the one I acknowledge is more statistically likely, given my history, is that I'm wrong, and that the court's still right in Wesson, and that the order of which things are done on a verdict form makes no difference at all. In which case, I still don't understand why not put not guilty first then. If it doesn't make any difference, why lead with guilty? Here's the thing, the parties in 30 years act like it makes a big difference. Defendants still request not guilty first, and prosecutors fight to the death to make sure guilty is first. So I don't understand, if it doesn't make any difference, why does it make any difference? Why not fix the optics of this situation and put not guilty first?
Counsel, in addressing that, I do have a question, would like your take on that. In many contexts in society, we see the question, guilty or not guilty. That is the question. From Shakespeare to TV shows to all sorts of contexts. And so does that in a way create an expectation in society, including jurors, that they may not read carefully because they expect guilty or not guilty to be put to them in exactly that way? And they may be confused.
That they would be confused if they had not guilty first?
Yes, if they didn't read it carefully, because we know that many times people don't read signs carefully. Many times that happens. And so is that in fact creating a potential for confusion?
So I think my answer to your question is, there's no, to the extent that we, argue you rejected the idea that the order makes any difference, there's certainly no evidence to the contrary I've never seen, like, for example, a defendant object, in the few cases where not guilty is put first, saying, well, this is going to be confusing to the jury, and I'm worried that that they're gonna, do something. I've never seen that argument put forward by anybody. And no evidence to support that. I mean, that's what I'm saying is if there's any evidence of any impact, it would be like the article that we cited, that it could be prejudicial, that when you give somebody a first choice, it tends even slightly to make persons prefer that choice, not the opposite, not in the way that you would be describing. So it seems to me like the options are either it makes a difference in that it slightly skews things for the state, or it doesn't make a difference at all, in which case still, there's no reason not to put not guilty first. That's my presentation, Your Honor.
Any question? Thank you to both counsel today for your arguments in this matter. We will take it under advisement. The court is now in recess until 11.